by Magistrate Lordship in 303 to surplus 2 BNS Act, a very small case. Before that decision, it was the bail was direction was that week commencing 21st of October.
Give yourself.
Till today, it's not listed.
I may be pardon your lordships. Item 30, your lordships.
Number 3170.
Give yourself.
Urgent period. Otherwise, it will not listed Monday. There will be infructuous period because on the basis of the modification of the
This is
Monday.
just a minute. Just a minute. See, I go through each and every slip, and 20% of the slips are rejected because either your handwriting is not legible, it is not clear, or on the basis of what is mentioned there, no urgency is met out. So, and when in all such matters where I find some urgency, I order for listing of those cases. Give your slips, we will see.
May be pardon your lordships. Item 30, your lordships.
Pardon to mention from the list, item number 33. I'm praying for an adjournment, but
Let the matter be called.
Matters under the heading for orders.
Yeah, so 7.
For orders, item number 6.
May I please, my lord? My lord, there has been a delay of 82 days. There has been a noting of effect as per some we remove. There also can't be 3 working days time to remove the defect.
Mr. Bimbisar Das, learned additional government advocate, raised for 3 days time to remove the defects pointed out by the stamp reporter. This is the case on 9/12/2024. Defect shall be removed in the meanwhile.
Item number 7.
Item number 7, my lord. Delay of 715 days. Certified copy.
2023, you still not filed the certified copies.
I was looking at that. It was filed in, sorry, it was applied for.
No, that is what I'm saying. By this time, if you
I'll
have
see that
instructed the office that is to file it.
I see that it no English.
739 days, what is the subject matter? Why should we
Subject
notice?
matter is, my lord. Can promotion be held up for a long period on the ground of pendency of vigilance case? The discipline proceeding was initiated in 2011. Till date, it is not been finalized. That is how he approached the court. The Honorable Single Judge has allowed the prayer, saying that no, you cannot hold up the promotion only because the vigilance case is.
No. So what is the operative portion of the order? Finish the disciplinary proceedings or give promotion?
Give promotion subject to result of the disciplinary proceeding. That is the order.
You should notice 8224 of 2023. Mr. Bimbisar Das, learned additional government advocate, undertakes to file the certified copy of the impugned order within 1 week. Within 1 week. Full stop. The I is considering the said submission, the I is disposed of. The certified copy shall be filed within 1 week as undertaken. 8/2/25 of 2023, this application has been filed for condoning the delay in filing the writ appeal. You should notice on the question of limitation. It is, returnable within 4 weeks. The deposits for which shall be filed. कितने दिन?
Within these 3 working days.
Within 1 week.
1 month.
This is the case after 6 weeks.
Right.
Say format करे पकड़े जो हमारा format है.
20th January.
20.
January.
The case is still pending. That matter is still pending.
Still pending. After receiving the file, I have asked the officers concerned, they will be coming tomorrow.
Yes.
As to whether it has been, in the meantime, some development has been there
In
or
the
not.
meanwhile, Mr. Das, an additional government advocate will obtain instructions regarding the
No,
disciplinary proceedings.
Right.
Regarding the stage of the disciplinary proceedings, yes.
Item number 8.
8, here is also a substantial question is involved, but delay is 917 days.
What is the substantial question?
Staff nurse, radiographers, and laboratory technicians, they were regularized after 6 years of their continuance as a contractual employee. But the petitioners, in the writ petition, they were not the staff nurse. They were not regularized. That is why they approached the honorable single judge. It has been allowed. Against that, we have come several SLPs are pending on this question.
Give one number.
Number, yes, my lord.
We'll pass over, you give the number.
Yes.
After
the
this-
orders,
After recess, we'll take up. Can
Yes,
you
ma'am.
give it? All right.
Item 9.
9, my lord, certified copy, your lordship may allow me 1 time. Within that period, I'll give it. And delay is 639 days. Here, the honorable chief judge has disposed of the writ petition, taking the judgment Sarath Chandra Parida's case into consideration. Our submission is that factually there are some discrepancies. No opportunity was granted to us. It was disposed of on the first.
Same order. They're dispensing with 1 week and say I get a returnable within 4 weeks or 6 weeks for a listing. So 20th January.
Item number 10.
10, my lord, there has
So
been
last
a
at least these 23 matters, you should have filed the
Yes, ma'am.
certified copies. Because we have been taking it up since 3
Yes.
weeks. In the meanwhile, the office can obtain and file it.
The other day I was submitting to your lordship that we have already written that anybody who is responsible for these defects, they will be taken to task. Because unnecessarily 23.
Do you think you can take them to task? You have to follow up.
Yes, we are following up.
Okay, all right, all right.
Asking them to come down.
So what? They will come down.
Yes.
Your staff has
No,
to.
staff, that is the problem with them. They are having the certified copy. That is the problem with them.
Online certified copy, you can get it within 2-3 days. Why do you have to depend on them?
Online,
That is what we are saying. They don't have to come just for filing the certified copies.
online we can give it.
All right. Yes, exactly.
In item 10, my lord, there
10.
has been a delay of 334 days.
636, I think.
Yes,
636.
Yes.
certified copy 1 week. You also can-
No, but why should we issue notice? You tell us what is the subject matter.
I said that certified copy, you also can do 1 week.
Thereafter, we will consider. All right. Mr. Ita khali certified copy for 1 week. List this case on 9/12/2024.
Item 11.
Condemnation will notice issue hour. Yes.
11.
Not of delay of 660 days and application for dispensing a certified copy. For certified copy, 1 week may be granted. And the issue involved in this matter is whether the entire job contract period can be counted for pensionable service. Learned Singleton is not considered Rule 18(6) of OCA pension rules, which is a ground taken in the writ.
The matters are pending and some earlier decision of this court is also there on basing on which the application has been allowed. All right. So should I your first order to process? So you file the certified copy within 1 week and requisites within 1 week also. The earlier you file it, the better. Within 1 week, it will be listed on 20th January 2024, 25. All right.
Item 12.
There is a delay of 293 days and there is
37, I think. 37.
And here also an application for dispensing a certified copy. For certified copy, 1 week may be granted. And the issue involved in the present case is whether respondent who is appointed in a micro project, which is a society registered in Society Registration Act, can be considered to be a government service. This is covered by your lordship judgment.
Which one?
Which was passed on 5/3/2024, State of Odisha versus Varnamali Farmer, in writ appeal number 1179.
117 of
1179 of 23. Judgment dated 5/3/2020.
State versus Varnamali.
Yes, madam.
Judgment dated 5/3/2024.
Yes, madam.
All right. It if you notice 1 week for this filing the certified copy and again returnable 20th January. Yes.
Item 13.
This is again a case where Sarat Chandra Koida judgment has been taken note of, and you are not doing the other cases.
Delay
Delay minus 307.
305.
Right.
All right. So that day of filing and day of when you get it, I think that we have not deducted. So it there is no dispensing this, only issue notice. Yes. The 20th January. Yes.
Item 14.
14, my lord, there is a delay of 59 days.
60 days. So amazing. No, amazing that it's only 60 days.
Like, until it was a 40 some odd days.
60 days, the stamp reporter has calculated 60 days. And it's under 100, it will be a surprise. Okay, the certified copy not received.
1 week.
The same order. Oh, sorry, what is the subject matter?
Subject matter, my lord. Continuance of regularization. Continuance for more than 20 years. They were engaged after the cut-off date. 15/5/97, you also may remember that government circular which says that somebody after 12/4/1993 there cannot be any appointment. Ban order was there. These applicants were
Work for 20 years.
that is their claim.
Okay, since the delay is only 60, all right. Already. Say 1 week and issue notice. Sorry, 21 the Sunday. 20th is which day? Huh? Monday.
Monday.
You can keep some to 21st. 14th or 21st. Yes.
13th. Sorry. 20th or next is 27th.
We'll keep to Monday.
Always.
Okay. 27th.
Item 15.
15, my lord, the delay is 316
16.
days. Certified copy or lodgement can be valid time. This is again sort of corridor case.
So Sarat Parida is item 15. How good?
Out certified 13.
13.
So,
So that
Batch.
13 and 15 can be listed together also.
Together, yes.
Whether with copy, 13 or 15.
matters.
So these two only. All right. What is the case number?
2949 double.
Yes.
The main.
The same thing, so this will also be 20 January along with that. Dispensing with the chief, so that will be disposed of. Yes.
Item 16.
16, my lord, there has been a delay of 232 days. That bad copy of what's me grant me 1 week time. Question, substantial question is, the respondent has claimed that after retirement, could not have been proceeded against in a disciplinary proceeding. Law permits me. If the incident occurred 4 years prior to his retirement, it can be rejected.
No, disciplinary proceeding can be continued, but under the pension rules.
Yes, ma'am.
Not
That is
under the,
yes, ma'am. You are- Under 7(2)(a) and 7(2)(b) of pension.
On same list on 27.
Item 17.
Item 70% matters been adjourned to 1912.
Yes, this has been listed only
Listed
for
for
correcting
correcting.
typographical error.
Yes.
All right, it will come up on the typographical error in order dated 21/11/2024 regarding nomenclature method regarding the case number is corrected. List the case on 19/12/2024 as directed earlier. Here, Mr. Dora. Yes. Batch websites. All right.
Page of case. Page of case.
And we are asking so that.
some local lawyer.
We'll inform the- Check for the outstanding last date to be listed with at least thought at all.
Item number 1.
My lord, that item 8, you also continue to give the SLP number.
Yes.
That I got SLP number is 14680 of 2021. 14680.
14680
Yes, ma'am.
of 2021.
Okay, the page for
Do you have the name of the party? State one, sir.
page the 8.
Name of the party has not been given.
Okay, so this was what did you say regarding
Regarding my lord,
jobs, not job?
regularization.
No, regularization, but what?
Staff nurse, radiologist, radiographers and laboratory technicians, they were regularized. But
Alright.
this MPA, HWs, they were not regularized. That question is pending for the Honorable Supreme Court in SLP number 14680 of 2020.
All right. Mr. Bimbisar Das, learned counsel, learned additional government advocate submits that similar matter is pending before the Supreme Court in SLP number 14680 of 2024. No, sorry.
21.
21. Sorry. Hence, issue notice and the notice, issue notice in the matter of condemnation of delay, so return of delay is 6 weeks per year, 27. Yes.
Best admission item number 2. That was number 1.
Referred by the state government.
Item number 1.
Wanted to be mentioned.
Sorry. The earlier order was on last. Fine.
Yes.
Item number 1.
That was,
Okay.
so don't call it after this. Sir.
Well,
Well, in fact, this matters about we mentioned. And my preliminary contention would be, Lordship, this matter was the last occasion on 2011 or 23.
2011, 23.
23.
Are you
And
sure?
Lordship, all of sudden this command to be mentioned without intimating me also with mention this card. So Lordship, at least
No, I must have passed some order.
no, Lordship, but I was searching there no such order.
Where is that?
I was searching there no such order.
Okay, no.
No, not order, mention slip, administrative
That-
order of the Chief
so-
Justice.
That is not within my knowledge. That's all.
Maybe
Okay, wait.
at the bottom of,
item number
on the bottom, Justice.
Yes. Where is Mr. Sharma?
Plan.
Detailed memo has been
Last class.
1761.
Mention. No, let me see, why did I do this? Yes, one mention memo was filed on
27.
27.
No lots.
By whom, Mr. Sharma?
By me.
Why?
For getting it for hearing of the case.
You are for the other side.
Other side.
MCL.
You can pick, this has been listed for fixing a date of hearing. Tell us.
Your Lordship, please tell in your early date, because the tender process has been held for more than 2 years. And your Lordship may fix any early date.
Eleven? 11?
11, that's the last. 11.
Yes,
11, any matter?
Just
6?
checking.
No, man. 11.
problem.
Matter on, with the consent of the parties. This matter on 11/12/2024 to be taken up at 12:30.
That's
Can
12. Sorry.
can I, on 11th is my younger brother's marriage, so can it be on 12th?
All
My
right,
younger brother's marriage is
all
on
right,
11th.
12 at
All
2. 12 at 2 p.m.
I never knew that.
12 at 2 p.m.
Right.
You invited.
The since the dispute relates to award of contract, the
Yes.
contract is an award of.
And then because the matter is pending, lot, we have not issued the
No,
contract.
he has given a very good memo. We understand the case by reading the memo.
But it is not the road was to be constructed.
So this is whether someone stopped you from.
No.
Just
Then-
because we were on caveat and we were asked to file the counter within 6 days, and due to pendency of the case, we have not issued.
Why?
No, justice
This is what we are trying to
I never
understand.
knew that. He had filed a memo, I never knew that.
Yes.
Item number 2.
Lordship, in fact, Lordship, can you tag another matter 17618 or something? 17618. Some Lordship. Other
Yes.
I don't
Yes.
know, Lord.
That is regarding another tender.
Lordship. If you contact the statement, in that case, Lordship, during the operation, same capital file, they have completed the work. But here, Lordship, they're taking
Over
plea.
in that
And because we have
case,
filed a capital, we did not.
No.
This is reapplication.
Okay, that is.
Because I am the senior counsel, engaged, I never knew that he has filed a memo, otherwise I would have instructed go on with the work.
Yes. All right.
Other application.
Other rate application, whether same work is same or not.
no, that's a different tender.
This same notification, same, this in similar nature of ground of rejection, Very self-employed clerkship. Both by the same employer.
So we make a mention. See, both the cases are to be heard together according to you.
Clerkship.
Why?
Very self-employed clerkship. They have appeared in both the cases.
All right.
They
in
find
that case,
there is some
if
counter.
the point is
I
saying,
can argue on that. Clerkship.
otherwise you can file a mention slip, we will decide. We will.
Clerkship.
Mentioning that reason.
Clerkship.
Automatically.
I fix it. Clerkship.
Let's. Admission.
Yes, sir.
Final disposal. Yes, ma'am.
Test admission item number 2.
Standard matter, my lord. In this case, I am the successful bidder. My lord, page 17, the tender process. In the page number 18, my bidding process was accepted. I was declared successful. But I was asked to deposit the FPS and ISD. FPS of 1 crore 50 lakhs and ISD of 11 lakhs.
Yes.
That is to be deposited within 7 days. My letter annexed, but I could not deposit the same because the bank did not supply me the BG, bank guarantee. So they issued him a letter that page 19 annexed 3 mark. They issued him a letter that as per clause, you are requested to deposit 1 crore 50 lakhs and 11 lakhs 40,000. You have not deposited. This is the reminder. Thereafter, I immediately wrote a letter requesting them to give some more time that I shall deposit the same. Page 29. Thereafter, without considering my representation, they asked me to submit an explanation why action will not be taken because of the non-deposit of the amount.
They say no explanation has been received.
And rightly.
My lord,
See, what is your prayer?
my lord, I have deposited that amount.
What?
11 lakhs.
That is immaterial.
Yes.
You deposited the amount after the expiry of date.
My lord, they have cancelled me. They have cancelled my tender, but not that is the case. After my deposit, after depositing of the amount, they rejected me that. The rejection order has not been communicated.
All right. That is immaterial.
No, that is there, Annexure 6.
No, my lord.
Yes, what is Annexure 6?
That is the annexure 6 is the remind letter to the officer, cancel his bidding. That has not been cancelled.
This has been cancelled.
My lord, I deposited 11
It
lakhs.
stands cancelled, Mr.
My lord, they have, at the time of rejection, after approaching the Honorable High Court, my representation when was considered, they disposed that we have rejected your representation, but they have not communicated my
All
representation.
right.
In the rejection order also, they have not intimated that you have not deposited or this much. I have deposited 11 lakhs. I have deposited 1 crore 50 lakhs also. They have accepted that. But they may be refund. They may refund that amount.
Don't know whether they will refund or not.
My lord,
Why did you deposit?
my lord, if I
Did they permit you to deposit?
yes, they accepted that, my lord.
They accepted, it's a different thing.
They
They
accepted.
deposited, it was deposited, that's all.
They accepted. They did not deny it. They
You
accepted.
can approach them for refund, we don't know.
With that observation, we disposed of my lord.
It is the petitioner's case that pursuant to, so this is your synopsis that pursuant to a tender notice issued on 17/10/2023. It is 23 in connection with what was the
Improvement.
connection with improvement through Suhagi MIP bracketed rest in nursing block of
Nursing food.
nursing food block of that district under RRR scheme for 2023-24. The petitioner had participated. First off, the petitioner was declared L1 And accordingly, he was required to deposit a sum of rupees 5,
10,50,000.
huh? 1,50,000,
1 crore.
1 crore 50,81,457 towards API and
APS.
11
Yes.
APS, huh?
APS.
APS
Additional performance.
and 40 lakh, 11 lakh 40,000, 40,400
Initial
towards initial security,
deposit, yeah.
initial security deposit in the shape of bank guarantee, duly placed in favor of Superintending Engineer MI Division Cuttack by
Within
Which is-
7 days.
within 7 days. So stop. The petitioner not comply with the said requirement of depositing the APS and ISD. So stop. On 16/3/2000, it is the petitioner's case that on 16/3/2024, he submitted a representation for extension of time for depositing the said amount of APS and ISD. So from thereafter, the superintending engineer, MI Division Cuttack, comma, referring to failure on the part of the petitioner to deposit the amount against APS and ISD. क्या लिखा? Thought an explanation as to why necessary action might not be taken against him in accordance with the codal provision. So stop. It is the petitioner's case. When did you deposit?
We deposited on 18th/4.
It is the petitioner's case that the petitioner much thereafter deposited the amount against a APS and ISD,
First
on
ISD,
80.
ISD thereafter.
ISD and PS on 18/4/2024
And 25/2024.
So ISD on
And-
18,
And
APS on 20.
and 25
yes, ma'am.
for 2024 respectively. In the meanwhile,
You know, the letter
The-
36, page 36, they have reflected that you are concerned. Page 36.
so have you challenged this 33/2024?
Representation we consider was
33/2024. This is the annexure 5.
next of 5. My lord, that is the explanation. Thereafter I submitted the request letter.
No, thereafter you came to the High Court, then disposal of representation, then rejected.
Yes.
And the decision is 18/11.
In the meanwhile, on 33/2024, the superintending engineer, MI Division Cuttack, wrote a letter to the additional chief secretary,
Chief engineer,
Central Minor Irrigation Circle, Bhubaneswar,
chief engineer,
hmm?
chief engineer.
Superintending engineer, additional chief engineer. Additional chief engineer लिखा है, हाँ? Additional chief engineer. To the effect that despite the petitioner was asked to deposit the amount, that amount against ISD and APS, comma, the petitioner had not deposited the said amount within the time prescribed. First off, a so-called notice was issued on 16/3/2024, but no explanation was received.
I submitted that. Yes.
No explanation had been
They have intimated.
received. Where is that? Where is the explanation?
Have you given explanation or only asked for time?
16/3 and 30/3.
16/3 on 30 till 33 there was no explanation available.
33 there is no explanation. But on 16/3 I have submitted an explanation.
You had asked for time.
That is 33.
Where is that? 16/3?
16/3 is the annex 7.
Annexure 7.
Yes.
Where is the receipt?
They have received. They received in mail, but it is.
Oh.
The mail also, there has to be that mail thing.
Yes, ma'am. They have received.
Annexure 7 is 33. You are saying 16/3.
No. Annexure 3 is 63, the lady.
No, 7.
He said, I'll give you few days.
Annexure 3 is 16/3.
No, 33 is also nothing.
33 they
Thereafter. 33. 16/3 you have not given any explanation. You are asking for time.
Time. 16/3 I requested for some time
So there we are
Some time
asking.
for what?
for deposit of it.
Therefore, you did not submit any explanation.
No, on 16/3 I did not.
Never you did not the case of the opposite parties is that you did not submit your any explanation at any point of time.
My lord, that is they intimated the letter to the additional chief engineer that by 30 March 2024, they did not submit any explanation.
Yes.
I submitted the explanation on 30th March. Annexure 7, man. Page 23, man.
So, but where is the receipt of even this 33?
Your letter is annexure 4, don't say annexure 3.
Annexure 4 is 16/3. I requested for time.
But there is no receipt.
Thereafter, they called me explanation. I thereafter on 16/3 pursuant to letter dated 16/3, I did not submit any. The representation is not available. But thereafter, they asked me that your bid amount will be cancelled. That is on 31st March. 30th March. There on 30th March, I submitted a representation. That you may please consider that am I asking.
What is it? There was no cancellation.
Given some explanation stating because of holidays, bank guarantee processing is going on. The explanation is given. You say that not yet received. All your emails must be there. Emails you can show.
Oh, there is no.
But there is nothing on record.
I have not.
It should.
No, nothing.
I am not.
Sorry. No explanation had been received. Accordingly, it was decided to forfeit the earnest money, deposit / bid security, and cancel the bid as per the OPWD code. Stop. It is the petitioner's case that on 30/3/2024, he made a representation before the superintending engineer, MI division, Cuttack.
Already it was received on second, it was received on 2nd April in their office.
How do you say?
My lord, that is page 36.
Page?
36, my lord. Second paragraph. Where is petitioner submitted representation which has been received on 2nd April.
Where is the proof?
My lord, they have intimated that in the rejection order, they have intimated.
Where is that rejection order?
Page 36, my lord.
Page 36 is the order of this High Court.
No, my lord, that is their rejection order.
Oh, sorry, that is 26. Sorry. 36, yes. Annexure 11.
Yes, my lord. In the second para, my lord, whereas the petitioner submitted his representation dated 30th March 2024, which has been received in the office of on 2nd April 2024.
Okay.
When did you file your writ petition?
On 30th March.
No, writ petition, when did you file?
When did you file your writ petition? The earlier writ petition.
Representation disposed on 19th April.
When did you file? So you file a representation on 30/3/2024.
Yes.
On 2/4/2024,
That was received by the office.
it was received, and you file a writ petition which is disposed of on 19/4
Yes.
with a direction to dispose of your representation which was received on 2/4.
Yes.
He had made a representation which was received in the office of
Okay, number 3. Important engineer, MI division. What of?
the office of which office? In the office of the superintending engineer, MI division, Cuttack, on 2/4/2024. Was from on 3/4/2024, the petitioner filed a writ petition before this court, which came to be disposed of by an order dated 19/4/2024, directing the opposite party number 3 to consider and dispose of the said representation of the petitioner and pass an appropriate order. So the petitioner's representation has been rejected by an order dated and by speaking order dated
2016.
26/6/2024. So which order was not communicated to you?
My lord, the rejection order, no bid was cancellation order.
When counsel appearing on behalf of the petitioner has submitted that the order of cancellation of bid was never communicated to the petitioner, and therefore the impugned order, speaking order, dated 26/6/2024, rejecting the petitioner's representation for, what was your representation?
I may be permitted 15 days time to deposit the FPS and IST.
Representation to consider the petitioner's case sympathetically and allow him another 15 days to deposit APS and ISD. Sentence, bro? Sentence. Allow. Requires interference. Stop. Next. It is the petitioner's own case that he had failed to deposit the requisite APS and ISD in terms of the communication dated 11/3/2024. So stop. In his representation dated 30/3/2024, he made a request to the executive superintending engineer for allowing him further 15 days time to deposit APS and ISD. When did you deposit that amount?
That is on 18/4/2024. 11 lakhs.
18 days thereafter, he is said to have deposited the said amount on 18/4/2024.
That is 11 lakhs 50,000.
Without, but you did not have the permission.
Yes, they accepted that.
No, accepted.
I sought
For which he had made a request through letter dated 30/3/2024. So stop. Next, the said representation dated 30/3/2024 to permit him to deposit the said amount has been rejected by the order dated 26/6/2024. So stop. We do not find any legal infirmity in the impugned speaking order requiring this court's interference. So stop. Learned counsel appearing on behalf of the petitioner submits that the opposite parties may be directed to refund the amount deposited by the petitioner against ISD and APS. So stop. Have you met this prayer? There is no such prayer made in the present writ application. So stop. The petitioner said next. Accordingly, this application is disposed of with a liberty to the petitioner to approach the superintending engineer for a refund of the amount. So stop. The superintending engineer of the said amount deposited by the petitioner as ISD and APS. So stop. It will it is expected that if the petitioner approaches the superintending engineer within 2 weeks from today, the superintending engineer shall consider his representation in accordance with law. Yes.
The second case.
Item number 3.
Second case, item number 3 also is also mine.
10.
No mine. In that case, and I was successful bidder. I deposited the ISD on within the stipulated time. That is page 26, mine.
Yes.
I deposited 10,30,000 within the stipulated period. But thereafter requested that the bank is delaying, the bank's letter is also page 27. Bank requested that some time may be given to us to prepare the BG. That may take some time. But in the meantime, they cancelled my bid. That is the one part. But second part is most important, that they blacklisted my case without giving an opportunity. My portal has been blacklisted.
No. Have they blacklisted or they have blocked your portal and said
They have
steps
blocked-
for
they have
blacklisting will
Yes,
be
madam.
taken?
They have blocked my portal. I am not applying for
No.
new tender.
Not that. Have they blacklisted you or they have blocked your portal and said that steps for blacklisting will be taken?
No, my lord. They have blacklisted.
Where?
It is subsequent to on 29 to 24. I have received.
Page. Oh, that document is not there.
No, my lord. After filing that is
That is why I saw the letter where it
Yes,
stated
yes.
that, yes.
they have blacklisted. That is the question. Without
Can
giving
you
an
comment?
opportunity, they have blacklisted.
Comment. In the subsequent, it is not here. Not in the petition file, that is subsequent.
You want second.
You filed on 29/7, it is on 2/9. 2/9, sorry, 2/9. Everything has been done. It is done.
If you are not challenging the blacklisting,
No, my lord. That was communicated after filing this review.
then you can challenge that. Not here.
Yes.
You can withdraw and
Because you have to take proper grounds.
learn counsel appearing on behalf of the petitioner after the argument seeks permission to withdraw this writ petition with liberty to challenge the decision of the of whose decision? Superintending engineer.
Madam?
Who has blacklisted you?
Chief construction engineer, Dev Irrigation.
Chief
Construction engineer.
Devagar
Dev.
Yes. To blacklist the petitioner by filing a separate writ application. The application is accordingly disposed of and with the liberty as on. Yes.
The portal may be open, my lord. I am not able to apply for the next subsequent tenders. My portal has been blocked.
Portal has been blocked and what can?
That is not there. There cannot.
See, if there are 100 contractors of your kind in Odisha, then no development work can take place.
That is, my lord, I am submitting that, but my portal may be open.
Portal, the conduct of your client. He or you participate in a bidding process. You quote your price in a manner that you are declared L1. You are not in a position to deposit the requisite amount. Because of that, the process gets delayed.
No, I am not.
So therefore, we are saying that if there are 100 contractors of your kind in the state of Odisha, no development can take place. And that is the reason why we don't interfere in such matters.
That might
So you should not be given any, it's a risk giving you any work.
My lord, I may be permitted to, I am obliged to that extent. But my portal may be open. I said,
Portal we cannot, we don't know.
Portal, you can make that prayer after the final order to merge it with this.
Yes, madam, with it.
That is open to you.
We make it clear that we have not gone into the issues raised in the present writ application, which shall be open for the petitioner to raise the subsequent writ application, which he may find.
Item number 4.
Yeah, please, Your Lordships. Tender was floated by the Odisha Lift Irrigation Corporation in the Jaleshwar division. And also is calling for the predefined criteria of the class of contractors from civil contractors of B to D class. And those contractors must have.
B is higher or
D is lower,
D is lower?
B is the higher. Along with that, they need to have a license issued by the Electrical License Board of Odisha of HT license. Means the tender was floated on 27/8/2024, and on 2/9/2024, the date of opening was fixed. However, there was a corrigendum issued, and the date was extended for submission of tender to 4/9/2024. Therefore, I submitted my bid on 3/9/2024. The rejection, all of a sudden, on 18th of November, I had submitted for 12 packages, and they gave a similar line of rejection that I have not submitted my tender as per the class of contractor mentioned in the tender. May I take your lordships to the DTCM, which mentions about the class of contractor, page 18.
So, what is your class?
My class is class B, which is higher, and along with that, HT license.
Class B.
Class B. I'll demonstrate.
Okay.
Annexure 3 series.
So, where is the impugn order? Let me see.
The impugn order is Annexure 6. It's a table. I have extracted the table in my page 7 of my writ petition. Which
You're at serial 7.
I'm it's at serial. There are 10 or 12 number of packages. Now, for which I had 10 number of packages, for which I had submitted.
Yes.
At page 7 of my brief, I've extracted that column.
Yeah.
Now, you also should see the serial number, package number, the name of the project, and the reason for rejection. Not accepted due to tender not dropped as per class of contractor related to DTCN. Your lordships to see page 18.
Just a minute. Where have you extracted?
Page 7.
Okay.
Page 7.
Oh, page 7.
Page 7 of my writ application.
I got it. Page 7 is
20931. Oh, sorry. I've opened the wrong one. Sorry.
Lordships.
Yes.
the same reason.
For same reason, in all the 12 packages, may I just place with your lordships page 18, which exactly predefines the class of contractor who can apply for these projects. It's page 18. It's the national competitive bidding through e-procurement, the execution of project work, column 2, class of contractor.
Which page, Mr. Das?
Page 18.
Yes, then
The class of contractor mentions valid civil D to B class with HT license. Then you'll also see my eligibility, which is an Annexure 3 series. I have the valid license bullets. This is an Annexure 3 series.
yes.
Page 82.
Yes.
This is my registration certificate. I belong to class B, which is valid till 2027.
Yes.
Then at page 83 and 84, there is a ELBO license, the electrical contractor license,
Yes.
which is also valid till 2025. Now, despite of submitting that, I had also sworn an affidavit to that effect. On 3rd of September, I submitted my bid, which is at page 94. There are 12 packages, and this is the reason which they mention that I have been rejected because I have not submitted as per the class of contractor. My humble submission with your lordships is, now this is a predefined criteria, and this is a mandatory criteria which I had complied, giving the details of my class B contractors. And
Where did you give those details?
Well, it's page 94.
Just one query.
Mhm.
I don't know if it makes a difference. Your registration certificate is in your name,
Yes,
and the electrical licensing license is in name of your firm.
it's actually a proprietorship concern. So this is in my name, and
I'm
this,
just pointing out that,
Right.
that there is something there.
they didn't mention anything on that. They at page
They
94.
are not required to mention everything.
So, page 95, I had given an affidavit. The proprietorship concern knowledge also lies with me.
So tender documents were filed by whom?
The tender documents are filed by my proprietorship concern.
And,
The proprietorship concern.
proprietorship.
Yes.
No, but the rejection doesn't say that contractor license is not, this is not as per class of contractor.
There can be two reasons for this remark.
Annexures 3 series, page 82. Class B. So class B is the higher class.
No, that is all right. We just trying to find out why it could have been rejected.
Let them file affidavit.
Class
File your affidavit.
B, diploma engineering, all right.
One more thing was, may I just point out before lordships? There was there was a
It happens. One of the cases we have decided.
I had received a text message from the tendering authority wherein they said earlier that one of my, if lordships take page 1 of my memorandum, wherein they said that 2 of my bids were accepted and admitted. And then this just after a few hours, I get a message, or rather, after a day, I get a message that it has been rejected. Well, there has been upright rejection in not accepting my class of contractors in which I submitted. And so far as the
No, well, let them file affidavit, and we cannot see this. You may bring this on record by affidavit.
Sometimes, if I'm not mistaken, all the bids which seem to be in order, they give a list first. And thereafter, the technical committee considers maybe another list then.
Even else what has happened, there are only
All right, let them file affidavit.
If they proceed with the opening of
They
the
can.
financial committee.
Last time we get
Time is
instructed.
allowed for. 2 weeks. 2 weeks time is allowed for the state to file. State opposite parties. So who are they? Who are you? Opposite party number?
Opposite party number 1 is the state. Opposite party number 2 is the lift irrigation company.
Who is for the corporation?
Go to notice. Take notice.
You should notice.
By speed
Opposite party number 2.
Yeah, we are given the option of both, but the problem is, will it be back within 2 weeks? That is the problem.
If I can take a special messenger also, since we'll open the financial bid and
Will you take the special messenger?
Yes.
take a special messenger.
Special nothing.
4
Yes.
and 5.
Item 5.
5 is the same.
All
5,
right.
5 is another.
I will say.
5 is same. So both of them are subject to the same class.
Yes.
DPL.
No,
Not the same. Date.
16/12. Item 18.
Possibly Monday.
This is the batch matter. This is a batch matter where the state requested to file an additional affidavit in the last page.
Data.
18.
Yes.
We have filed counter affidavit and we have adopted the counter affidavit in all matters.
If my lord may look to the order dated 22/2024. There is an instruction to file a affidavit to this effect within 2 weeks.
Mention memo was filed by you.
This one.
Oh, it was there last week, or this week or last week? Okay. Oh, so that mention memo is there, that.
Yes.
Order dated?
22/2024.
22.
22.
Second, sorry, 20th February.
28th February.
28th February.
The first application, Premier.
No, my lords, it was clubbed with a.
All right, so you wanted to see the order in which writ application?
My lords, that's what I'm trying to explain. My lords. These matters were clubbed together with another writ appeal 17625 of 2023.
Which was listed yesterday?
Writ petition.
All right, so where is that order?
My lords, it's with me only.
17625 लिखे और लगभग खाली प्रॉब्लम है कि इसको चला Please give that order.
Yes, what is the dispute about?
Because this is a dispute with regard to the additional charges which has been subsequently enhanced. Because what has happened is that additional charges are the basic price of which auction is being conducted. The additional charges are fixed by the government with a notification for auction. And after execution of
Tuesday, I think those matters were there. I think some matters were listed on Tuesday or Wednesday.
yes, ma'am.
Yes.
This-
So lease for 5 years, but every year fresh lease has to be executed and they're increasing the APS.
Absolutely.
Last 2-3 days. Probably reached at the last hour, so. He was showing us an earlier order where he was allowed to continue on basis of something.
My lords, that writ petition was for the subsequent year. That's the demand they are not issuing for the second year.
So here you have an interim order.
Yes,
Now this
madam.
come for
This
final
is the first
disposal.
year where they have enhanced the additional charges
enhanced.
arbitrarily.
Interim order in your favor, I
Yes.
guess. Which order you were showing us in the other writ application?
Yes, Your Honor, sir.
So, what was that? For 5 years. APS, every year they're increasing the. So this is not the first, this must be the second year.
This is the first year reads.
So first year, how can they increase?
That is why we are challenging
First year also they've increased.
They have increased.
Okay.
After execution of lease, while they are operating over the mines, they enhanced it and they requested for additional demand. They issued an additional demand.
Interim order in these cases, so that interim order is showing us. They were for a notification. Probably there was no time, so we are attending to somebody for filing of counter accusation. Are you aware when that is listed? The matters were there, I think Tuesday or Wednesday. So when are those matters posted?
Those matters are for the second subsequent year. It is for the second year.
I have understood.
Yes, ma'am.
The question is same.
When are
The
they
question
posted?
almost same.
You don't know.
But I'm not aware of this. Next.
You are the petitioner, it is this on the tender.
The only question is that
Whether they can do
how
that.
can you alter the conditions which were agreed upon between the parties? That is the only question.
That is the sole question, but this is not the fact. We have never altered it. We have adhered to the earlier the circular, but there was a computational error regarding computation of additional charge. Therefore, we have stated it clearly that there is a computational error for which this amount there was a discrepancy. So please pay the differential amount.
So how are you showing us that there is a computational error?
That we have calculated.
No, when was that circular issued?
No, not circular. It's a order, he's challenging Annexure 12, your lordship can see Annexure 12.
Annexure
At
12 or
page
which writ
67,
petition?
at page 67.
Which writ petition?
That, my lord, first writ petition, my lord, 21573 of
Yes.
2020.
Annexure 12.
Annexure 12 at page 67.
Yes.
Revised demand for delay in execution of the lease deeds. So and dated so and so. We have stated this is to intimate you that at the time of auction of so and so site on 28/3/17, the rate quoted by you was 130 plus 40, for which you had been adjudged as the highest bidder. Accordingly, the demand notice was issued and the lease deed has been executed. After receipt of the mandatory permissions like the grant of the competent authorities from respective competent authorities. However, on scrutiny on the case record, it has come to the notice of this office that the additional charge has been substantially enhanced by the district level committee, so 130 plus 193, at the time of execution of agreement on dated 14/9 to the file letter so and so, based on the instruction received from the, so it's earlier, before execution, there was an instruction. They have also annexed that document. They have not challenged that. So far as that the document is, that is not under challenge. Revised demand, so that letter already enhanced, which could not be taken note of while computing.
No, the
Therefore-
action, the auction was held on 28/3/2017.
Yes, my lord.
And you are referring to instruction received from Additional Chief Secretary dated 7/4/2022.
7/4/2022, yes.
That
Yes, ma'am.
instruction is at page 50. My lord may evaluate.
No, your lordship
That
may
is
see that
most of
document,
instruction
7/4/2024, your lordship may see. That 7/4/2024 is at page 50. Page 50.
Yes.
And this is not assailed in this writ petition. They have accepted it. They are accepting it.
Why have you issued it to them? Why should they accept?
No, it's a circular, departmental circular. And
Office-
under rule,
it's
under
an
rule-
office order addressed to your
yes, it's a
officers.
departmental circular based on the statutory provision, that is rule 25. my lord.
Let us understand one thing.
Yes,
It refers to fixation of minimum guaranteed quantity
yes, and
Right.
additional charges.
and additional charges. So whether this additional charges
Ma'am.
was there before issuance of 7/4/2022 or not?
Yes, that is a statutory prescription
Where is that?
under rule 25 of the Constitution. Under rule 25.
You're showing us letter dated 49. 49 or what is it? 42. 49 is contribution of the committee. Thereafter 7.
Rule 25
All correct.
of 2016.
Yes. Yes.
May I please note? 25, liability for payment of royalty, dead
Yes,
rent,
where is the
amount
additional
for
charge?
district mineral foundation, additional charges, etc. The holder of prospecting lease from mining lease or mining lease shall be liable to pay dead rent, surface rent, royalty, additional charge.
So where is that additional
My
charge?
lord, additional charge 25, rule 25.
25 that we have seen, but where is the additional charge? See, this must have been there when the auction was held.
My lord, that's an annexure.
Additional charge, it's in
No, we are just seeing, maybe we have the old book. So we are just checking.
25.
Yes, 25 is before us. Again, old book, I think. Oh, yes. Oh, what is this? 2021. What is the year? Oh, this was in the year 2017.
No, my lord, yes.
No.
I am holding it
You
at
are holding it is fine,
Yes.
but when the auction was held,
auction held, my lord,
2007.
so.
2017.
So when did this come? Because we are holding a book 2021, so when did that?
No,
That
these
doesn't have.
rules are of 2016.
Before execution of agreement, that has been the, before execution, auction may be there, my lord, but so far as execution of agreement is concerned,
All right.
that will be calculated,
Liable
that
to
will be executed date of execution of agreement.
So where is the lessee shall
What is the date of execution of agreement?
Date of execution of agreement. Four nine 2022.
Date of execution of agreement, first agreement.
Yes.
What is the date of first agreement?
Yes.
What is there is
2022.
we have to take certain clearances, environmental clearances.
Auction was held in 2017 and
17.
agreement in 2022.
22.
Yes.
Because we obtained our CTO and CTC.
What is the
according
date of agreement? What is the date of agreement?
14/9/2022.
2020.
14/9/2022.
So this has come before that. Only thing first year.
All right,
we-
so, Mr. Counsel, you are right that under Rule 24, a holder of license is liable to pay this additional charge also. But
25.
at what rate? When was that decided?
That rate will not,
Because the royalty, the calculation is there
yes.
in rules 25. Additional charge.
District level committee that has been formed. Lordship may see annexure, that's page 50. Page 50. Fixation and additional charges. The modality has been prescribed here.
Where?
That page 50.
Where?
Page 50.
Page 50, second para. Additional charges based price on which the auction for lease of a minor mineral source is conducted stipulates rules 16 stipulates the lowermost limit of to the modality here. There are even instances of notable difference between additional charge of two different sand sources situated opposite to each other in the particular river when the quantity of the sand remains almost the same. Similarly,
Here. Additional charge and the rule stipulates that the lowermost limit of it
yes,
shall not less than 5%.
5% for the rate of royalty.
So you fixed that thing, but later you thought that it is too low.
No. We have fixed it, but when it was charged, there was a
Where
computational.
you fixed it? This letter says it is low, so raise it.
Yes.
So where have you fixed it?
Initially, we issued a demand. We complied with our demand. That it is not a case, my lord, that we have not exempted and then subsequently we have added it. We have issued a demand. He complied the demand. We found an error after the scrutiny. That scrutiny is at our annexure.
So your
Annexure B.
error.
On scrutiny, we found annexure 12. That is the word mentioned is the scrutiny.
Annexure 12.
Annexure 12, but that is the impugned annexure. Impugned order is the only, annexure 12 is the only impugned. 1, 2, 3, 4, fifth line. However, on scrutiny, this is the only input. I said, Lordship may see if there are any error, infraction, then your Lordship may interfere.
No, but
However, on scrutiny of the case record, it has come to the notice of this office that the additional charge has been substantially enhanced by the district level committees to so and so price at the time of execution of lease agreement on height so and so on instruction received from the office of the additional chief.
you got the date wrong or lease agreement was on 4 or 14?
Yes, yes.
What did you say?
14, 11,
14.
annexure
All right,
11. Annexure 14/9/2022.
There is a
That
document that it had been enhanced on 14/9/2022.
what is the document?
Yes. This is a subsequent document stating that it had been enhanced. At the time of execution, it had been enhanced.
It had been enhanced.
So the letter which you are referred to says that it low, it should be enhanced.
Yes.
Nothing is written. So whatever you feel like you can enhance.
No, not like that. No, we have given the calculation.
See,
Revised
come
demand
to
for first year.
page 50.
In table,
Page 50, page 50.
page 50,
Come-
Lord. Yes,
Come to page 50.
page 50.
So this is a letter written by the additional chief secretary.
My lord.
This is not the law. This is just a communication
Yes,
based on some law.
based on,
Might have the
My lord.
relator might have discussed certain provisions.
my lord, my lord.
Now come to paragraph 2.
Paragraph 2, additional charge.
Hmm.
Is the base price on which auction of lease of a minor mineral source is conducted. Odisha Minor Mineral Concession Rule 2000.
Just a minute. So the first sentence,
My lord.
so how is this supported? This observation that additional charge is the base price on which auction for lease of a minor mineral source is conducted. Where is that?
In statute.
Yes, must be there. Yes, it must be there, Mr. Counsel. Where is that?
My lord, in definition, rule 2, in definition, then it has been defined. Additional, what is additional charge?
Amount payable by a successful bidder on unit quantity of minerals.
Yes.
Towards,
Yes.
yes, how is it to be calculated? Because the letter you are referring to
Yes.
also says that 5% is the minimum. So it is up to you to, specify how much.
I will file a detail affidavit. Lord, sir, may grant me
See,
some time.
annexure 1, they have calculated it.
Exactly, they have calculated, they are saying it is low. So once you calculate, you can increase, but
So calculation process, your lordship.
See, if whatever is required to be statutorily paid,
Yes,
they'll have to pay.
they have to pay.
If there was any discrepancy in the calculation, that can be rectified. We just want to know the legal backing of your decision. That's all, Mr. Counsel. If you fail, then you fail. If you succeed, then he fails.
He is agreeable to pay the additional charge. He doesn't sell this annexure, page 50. That levy of additional charge, he is not selling.
we cannot.
He cannot. And now, when we found that the computation, that computation he is not challenging. That we have to explain. Lord, sir, may
Exactly,
grant-
so you get instruction that how.
Yes.
How is
Whether
it-
affidavits have been filed, affidavits have been
It
filed.
is adopting the counterfeit in another case.
Yeah.
Similar matters.
Then what further instruction do you need?
Yes, I will seek further.
What?
Further affidavit explaining that one wonder what basis the computation has arrived at and the differential amount has been arrived at.
So that is not mentioned in your affidavit.
Yes, affidavit says that whatever we have done by annexure 12 is correct. And we have taken the stand that the alternative remedy is available under section rule 46, appellate forum. He has not availed them, directly come before your lordship.
So why are you not availing the appellate forum?
This is not as per the mineral concession rule.
And you can go make your submission before the appellate authority.
Yes. Appellate authorities are, the demands are not as per the mineral.
Maybe you have a forum you can approach.
Let them exercise
cannot-
their mind and reveal it. Thereafter, your lordship will interpret.
All right, you file your affidavit.
Let them approach the appellate forum. Let them be given an
Let us see.
opportunity to exercise their mind and
Let us
reveal the fact before your lordship.
No, fact is there, you can reveal here also.
Appellate authority
If
bypass.
some other consideration I can understand, because once he has
Yes, yes.
executed,
Matter on.
After execution also liabilities are there to go on paying these type of payments. After execution, there is a liability continues. It's not that ordinary tender like that, rules cannot be changed after the game has begun, not like that.
No, that you cannot do. You cannot enhance. See, this is on the principle that that he had,
you should know what he is doing.
he had agreed to do something based on your representation. Now he changed his position. Sir, he will be governed by the promissory estoppel.
Before execution, that additional charge and power is there under the statute, my lord. Whether we have exercised that power fairly or not fairly, your lordship will examine.
No,
That
that-
we have to require file.
See, if your computation is incorrect,
Then we will explain it.
then
So
it's a different matter. But if you have introduced some policy, you have taken some decision After the agreement, then it may be difficult for you to defend.
Basis of the computation you have to give us.
List this matter on 2 weeks so as to enable
3 weeks, well, kindly give 3 weeks.
3 weeks so as to enable and counsel for and EGA to file an additional affidavit supporting the decision to charge
Why annex 12?
to charge to support the revised demand against additional charge.
Yes, ma'am.
First case,
2 weeks.
Please see that your letter is dispatched.
Sure. Great.
Give you this, my lords.
Also, government has already filed counter. I have to file the rejection.
It should be amended, but we may be required to file an additional count.
Yes.
So far as amendment.
No interim order.
No interim.
You want to file amendment or rejoinder?
Amendment as well as rejoinder to the counter affidavit also, ma'am.
So time this matter has been adjourned for one reason or the other. And why it has been listed for the revision bench? Earlier it was listed before we learned singleton.
Mines and mineral at that time.
No, but therefore,
Checking. There is a usual before this case. Why it has come? 3/7/2024.
Yes.
Already it is 3/7. So here blasting permission has not
Yes,
been
yes,
given
yes,
to
yes.
you.
Though I have been allotted to operate the stone quarry, but blasting permission was not granted. I have applied, and in the counter they have stated that there is a objection. Accordingly, I want to amend that objection which has been raised. That has to be need to be
So
challenged.
objection, the villagers or some.
They are saying Tahsildar is saying that villagers are opposing.
So you file, you can't, what will you do to that? Villagers oppose because their houses will be affected.
I want to challenge that report, my lord. So, I mean,
what was your prayer?
Granting blasting
prayer is
permission.
to grant blasting permission. Though I have been allotted to operate the stone quarry,
So whether that was rejected or
that I have already made representation. They have not yet communicated anything, but they have filed the counter. In there, I want to they have filed a report of the Tahsildar, in which the Tahsildar said that there is a public objection by the villagers not to operate the quarry.
My lord, we'll take a final.
Otherwise, 1, 2, 3, 4, 6, otherwise there is no.
No objection.
Only the last one.
Yes, yes.
That is that page.
But the forest clearance is there.
but you are required to take a decision.
Yes, yes.
So that
We'll take a decision with lots of it and 15 days time, we'll take a decision.
Better they take a decision
Yes,
thereafter. They are agreed.
my lord.
the writ petition, present writ application has been filed seeking a direction to the opposing party number two to issue blasting permission for Nilkanpur stone quarry located at plot number 79, khata number 68 over 68 of Banpur Tahsil under Khurda district for which the petitioner has made an application. First off, the petitioner has been granted lease of the said stone quarry in 2021 itself.
In 5/1/2023, right annexure 5, the Tahsildar has granted to allow to operate the right annexure 5.
5/1/2023.
5/1/2023.
The general stone quarry in the year 2023.
Yes, my lord.
Right annexure 5.
Annexure 5.
Bracketed annexure 5. Stop. List this matter on 2 weeks within first 5 cases, so as to enable an AGA to seek instructions as to whether any decision has been taken on issuance of blasting permission in favor of the petitioner or not.
2 weeks.
2 weeks.
Item number 20.
Non-implementation of order dated 4/4/2023 under Annex 1 in a W number 1608/2022. Operative person, kindly see page 13, madam. Page 13, para 9. Dr. J.K. Linkal and counsel for the appellant submits that during the 11 months when the appellant was under suspension, he was not paid any substance allowance. Mr. R. Minister, additional comment advocate appearing for the state resonance assures the court that the substance allowance due to the appellant will be paid to him not later than 4 weeks from today. Para 10, the appellant will be allowed to resume duties and appropriate orders in this regard will be passed by the governing body of the college not later than 15 April 2023. The impending order of the learned single judge is set aside. And para 10 has already been implemented, and para 9 till it they have not implemented.
Last occasion, Lordship was pleased to grant me some time to obtain instruction regarding if the review application has been dismissed in the meantime, what is the stand of the government? My lord, I have obtained instruction, and the instruction is that on similar question of law, more than 200 writ appeals are pending before this honorable bench, my lord. And the question is, my lord, whether the has been filed in states on the ground that the 1974 rules, which is the rules that he is relying, is not applicable to the employees of the block grant higher secondary schools, and Honorable High Court have issued notice. So that rule, whether it will be applicable to them or not, they on the basis of that rule, Lordship disposed of the writ petition. We went on review. That review has been dismissed. Now that writ appeal, my lord, we have filed the writ appeals.
Several cases are there.
Several cases are there.
Rule 3 of the 74.
Yes, yes, rule 3.
Whether block grant employees will be covered under that definition or not, that is the subject matter of consideration. Actual language, the Rule 3 language doesn't allow block grant employees who are in receipt of full grant period. That is the language used.
In this regard, the petitioner filed an affidavit on 13/11/2024. Kindly see flag B. The principal of the college has submitted the bill amounting of rupees 5,44,146 towards payment of substance allowance for the period from 1/5/2022 to till 12/5/2023 to the petitioner. But in spite of direction of this in court, this hearing has not yet been implemented, my lord. Under Annex 8 in the affidavit, my lord.
So this order have you challenged?
My lord,
This order?
the review,
No, this. No, review in this or?
in this case, review has been dismissed.
Dismiss, my lord.
Similar from the last,
Yes, what is the question? What is the legal question?
that is the legal question is that pursuant to the direction orders of this honorable court has been partly complied with. And
No, which order, which rule is not applicable?
that, my lord, Odisha Education Recruitment and Condition of Service of Teachers and Members of the Staff of Aided Educational Institutions Rule 1974
Will not apply to?
the block grant schools.
Yes, and therefore, this rule was wrongly applied in this case, according to you. But rightly or wrongly, this is the order which you are required to comply with. So, how will you do it? The legality of the order cannot be gone into. So you will have to implement it. That will not prejudice your case in other matters, but this order you will have to implement. You will clarify.
And that 2 weeks more time maybe.
So the suspension order has been set aside.
Yes, he has been reinstated.
He has been reinstated. What have you not paid? Subsistence allowance.
Yes, my lord, that
Subsistence allowance.
So you'll have to pay. Who will pay?
The principal has submitted the director before the director.
Comply with the order.
My lord.
Otherwise, we have no choice.
Either will, my lord, you have to pay that or we will join in the WA, my lord.
How can you join WA? WA has been rejected, review has been rejected.
WA rejected.
So here nothing can be done.
Then nothing can be done. Your lordship may grant me for. They have taken the excuse at law department opinion. Two weeks time may be granted, we will implement it. Because there is no choice.
The division bench of this court had disposed of a writ appeal filed by the petitioner with following observation and direction. Paragraph 8 to 10. So talk. When counsel appearing on behalf of the contemners has submitted that that a provision that the second proviso to Rule 21 bracketed 2 of Orissa bracketed education and condition of service of teachers and members of staff of aided educational institution bracketed rules 1974. Start. Is the basis for the aforesaid direction and order of this court. First of the rules of 1974, he contends, do not apply to block grant teachers.
Yes, block grant.
So,
Block grant called institution.
yes, to the teachers of block grant institutions.
Institution.
Yes. This is your case.
Yes. Block grant is
in the receipt of block grant.
The institutions and receipt of to the employees of the institutions in receipt of block grants by the state. So, this said aspect of the matter cannot be gone into in the present proceeding, present contempt proceeding. So, we have been informed that a review application filed against the said order of this court has also been dismissed. Where is that order?
Dismissed on 25/4/2024.
Where is that order? On the ground of delay. Full stop. Next. In such view of the matter, the opposite parties have no other option but to carry out the said order of this court. So stop place this matter on order dated sense of this court. So stop place this matter on 2 weeks. So in the meanwhile, if the order is not fully complied with, the court shall have no other option but to proceed against the opposite parties in the party for deliberate disobedience of this court's order. Yes.
Item 21.
May I please notes with my lord's kind permission and through VC. Lord, during after discharge of lengthy 20 years, more than 20 years of unblemished service, the appellants were given an opportunity of being appointed to the post of banking assistants as per the policy decision dated 18/1/2018 of the respondent number 5, that is our employer, who is that is of the ASCA Central Cooperative Bank Ltd, ASCA, opposite respondent number 4. My lord, our promotion was put to challenge by the respondents number 6 to 13 in a dispute case number 138 of 2018 in the Court of Learned Registrar of Cooperative
Let us
Society.
come to the order first. Order
Yes.
of this court.
Yes, my lord. My lord, sir. My lord, the impugned order is considered.
Yes.
My lord, that is page 82, relevant page 82. The observation of the, my lord, of the honorable single judge is beyond the pleadings of the parties. That is my sole grievance before my lords. Learned Counsel, para 11, learned counsel for the opposite party number 4 and 5 further submits that before taking the decision, the opposite party bank not only resolved to fill up the post of banking assistant to the extent of 30% earmark for the employees working in different societies affiliated to the bank, but also sought necessary permission from the opposite party number 2 to relax the upper age limit by letter number 7/4/2016 as a one-time measure, since no decision had communicated on such request to the opposite party's bank. The bank, on the bona fide impression that the proposal submitted by letter dated 7/4/2016 has been accepted by the opposite party number 2, hence took a decision on 18/1/2018 to appoint the present petitioners and 9 others banking assistants as against the aforesaid 30% earmark for the employees for working in different societies. He further contends that in view of the inquiry made by the opposite party number 2 and 3, that was the subject matter of the writ application before my lords.
So what was there on record according to you?
My lord?
What was not there on record? What is beyond pleading?
My lord, that is regarding the amendment is concerned. What is observed at
Amendment is not required to be pleaded.
My lord, that is at page 80.
Law is not required to be pleaded, Mr. Counsel. Law is not required to be pleaded.
No, my lord, this aspect, the amendment is subsequent to our promotion, which after filing the writ application. My lord, my sole grievance before my lords is that when the dispute case, statutory dispute on section
Your grievance is immaterial. Whether there is any illegality in the order, that is to be seen by this court.
My lord,
What is the illegality?
The illegality is committed by the respondent number 2 that has
The
not.
respondent might have committed some illegality, but what is the illegality in the order passed by the learned single judge?
My lord, that is regarding page 83, my lord.
Yes.
Page 83.
Yes.
Para 13, learned counsel for the opposite party of 4 and 5 further contends that although the staff service rule has been amended in the meantime, the appointment to the post of banking assistant should adhere strictly to the eligibility criteria of non-cadre secretaries, such as the petitioners. That was beyond they have admitted the respondent number 4 and 5, they have admitted in their.
This is beyond pleading.
That is at finding place at page, that is page 43, my lord. 43. Lord, para 4, that entire contention of the appellants were admitted by the respondents number 4 and 5. Para 4, that is very important, vital, that at the outset, these opposite parties beg to state that the present petitioners, along with 9 others, were promoted to the rank of banking assistant as per the decision taken by the Committee of Management in its proceeding dated 18/1/2018, all were reverted back basing on the direction instruction issued by the opposite party number 2 in the inquiry report dated 29/6/2018. My lord, then my lord, may kindly have a glance to come to page 55. That is counter affidavit filed by the opposite respondent number 2. Para 10.
So you want us to set aside the order of the learned single judge?
Only my humble prayer that setting aside the impugned order, the respondent number 2 may be directed to dispose or take a lawful decision in the dispute case number 130.
This is what has been done by the learned single judge.
No, my lord. The dispute case, my lord, single judge has found no opinion regarding pendency of the dispute case under annexure 3, my lord. Annexure 3. That is a dispute case. Our appointment is put to challenge in that dispute case, 138/2018. And while
What was the dispute case? Where was that pending? Where is that pending?
That is pending with the opposite respondent number 2, my lord, under annexure 3, my lord.
Who are you?
My lord?
Who are you? Who are the petitioner appellants?
Appellants were given promotion by virtue of the policy decision.
Appellants were given promotion to which post, from which post to which post?
To the post of banking assistants.
Banking assistant.
Yes, my lord.
So the dispute case is promoted to banking assistant.
Yes, my lord, under annexure 1 series.
Just a minute, from which post?
from the post of cadre secretaries.
Cadre secretary.
Yes, my lord.
And the dispute case is pending before whom?
Respondent number 2, that is Registrar of Cooperative Societies, Odisha.
The dispute case is pending
Yes, my lord.
regarding this promotion.
Yes, my lord.
Regarding this promotion.
Yes, my lord.
So why did you file writ petition?
No, my lord, because while the dispute was posted to, that is, my lord, may kindly have a glance to page 33 for a moment. 33. An order is passed, under order annexure 3, an order is passed on dated 2nd June 2018. The learned advocate for the parties are present. The learned advocate for the defendants filed petition for 1 month time to file WS. He also filed a petition with copies served for expert. The dispute was posted to 21st July 2018. The last sentence, my lord.
Yes.
While the dispute was pending, posted to 21st July 2018, we were served communication of aggrieved orders under annexure 4 series. That is as finding place at page 34.
Whether the dispute case was decided?
No, my lord. That is pending. That is my whole grievance before my lords.
Then why did you come to this court?
My lord, because annexure 34, in view of the order passed by the respondent number 5 with reference.
Dispute case.
No, my lord.
Then?
In pursuance to the letter dated so and so dated 29/6/2018 of the Registrar of Cooperative Societies, Bhubaneswar, and the resolution number 5B of the Managing Committee.
Mr. Counsel, please let us understand a dispute case was pending regarding your promotion.
Yes, my lord.
Why did you file writ petition in 2018 when the dispute case was pending?
No, my lord, because of this order dated 9/7/2018 of the committee under annexure 4 series.
9/7?
2018.
So 9/7/2018. So this issue could not have been raised before the in the dispute case.
No, my lord, because as per the direction of the Registrar of Cooperative Societies, the Committee of Management took a policy decision, decided to revert back us. That was the grievance before my lords.
So whether that could have been raised in the dispute case or not?
No, my lord, because there is no scope with us. Because the authority who was supposed to take a decision in the dispute case, he unilaterally.
Very good. Just, Mr. Counsel, there was some decision which could not be raised in the in the dispute case. Therefore, you filed the writ petition. Now, why do you want us to direct that the matter should go to the dispute case should be decided?
No, my lord,
independent of dispute case.
In the dispute case, we were the defendants, my lord. We are defendants.
So defendants, then let them decide.
Yes, yes.
The Honorable Single Judge has passed this order relying on the statement made by both of them. Your Lords may kindly see page 83, para 13. On their agreement, this order has been passed.
No, my lord. That is not my submission.
Para 13 may kindly be seen.
That was on basic submission of the respondent number 4 and 5 only.
Although the staff service rule has been amended in the meantime, the appointment to the post of banking assistant should adhere strictly to the eligibility criteria of non-cadre secretary, such as petitioners. In this regard, and counsel appearing for the opposite party of Court of Mind committed that if this court directs the opposite party number 4 and 5 to reconsider the case of the petitioner in view of the amendment provision and subject to petitioner satisfying the eligibility criteria within a stipulated period of time, then he will have no objection to such a direction. Now, your Lordship may kindly see Annexure 9 at page 85. They are the persons who submitted this judgment seeking implementation. Annexure 9 at page 85.
My lord, may kindly have a glance to page 65.
All right. Next case.
Item number 22.
Yes, well, the election of the respondent to the office of the Sarpanch was questioned by filing an election case before the concerned tribunal. But on the ground that the respondent was unable to read and write Oriya.
That
That
is not
was
maintainable.
maintainability. I'll address your lordship because your lordship was pleased to ask me regarding the maintainability on the last occasion. I'll assist your lordship on that point also. But similar kind of issues cropped up before this noble court, and this noble court has been pleased to hold that the writ appeal is maintainable. I'll just assist your lordship with these authorities. First of all, let me just humbly clarify one thing. That is, my lord, extra copy for me. Here, it has 2016. No, अच्छी, put extra copy. 2016 to CLR page 350. Your lordship may kindly turn to page 352, paragraph 5. This issue relating to maintainability, and this was the matter under the provisions of Orissa Gram Panchayat Act, was raised before this noble court. It is like this: Ms. Deepali Mahapatra and counsel appearing for the contesting respondent number 1 raised a preliminary objection with regard to maintainability of this appeal, and further contended that if there is no civil judge junior division available in statutory jurisdiction itself, it is only the additional civil judge junior division having jurisdiction over the same who can entertain the application. And thereafter, the other contentions were raised. This contention was dealt with in paragraph 6 and 7, your lordship, by specifically formulating a question as to whether the writ appeal is maintainable, and ultimately, by referring to the case of Radhesham, which and Joginder Singh case, it has been held that the writ appeal is maintainable in paragraph 9.
That as per this decision that has been decided in Saswati Patra, paragraph 8.
Marital.
Paragraph 8 of the judgment you have given us.
Marital.
The court did not decide here, basing on the decision in Saswati Patra.
Saswati Patra case, my lord, I'll assist your lordship. I'll produce that, my lord. There is one more authority, my lord. I'll just produce your lordship. That is again reported in 2019 to ILR Cutter, page 18. It again.
So this is based on 2015 volume 9 SCC, page 1.
That I have got, my lord. I'll produce it, my lord. Therein, the Honorable Appeals Court held that tribunals are amenable to Article 226 of the
Let us see the
Constitution.
decision. Paragraph 5 has been quoted.
My lord.
Paragraph 45 and that decision has been quoted. So how do you justify this, what has been held in paragraph 9 with reference to what has been held by Supreme Court in paragraph 45?
My lord, paragraph 45 is the summary of the conclusions in.
So therefore, the writ petition which you had filed before the learned single judge.
I had not filed. The other side had filed.
The other side has filed. Whether that was under 226 or 227?
That was under both 226 and 227.
220. That cannot be under 226. This is the law. This is the law that cannot be under 226. That was under 227.
Will your lordship kindly refer to that Joginder Singh case I have produced just now? Paragraph 7, your lordship may kindly peruse. Paragraph 7 of Joginder Singh case.
Yes.
By referring to Hari Vishnu Kamath case, my lord, that has been taken note of. A 7-judge bench, while dealing with the scope of proceeding under Article 226 of the Constitution, observed that there can be no dispute that the orders of the election tribunal are subject to supervisory jurisdiction of the High Court.
Just a minute. Yes.
And it has been also held, let me humbly clarify, that whether that will take a character of 226 or 227 will depend on the fact situation of the case. Now, your lordship may kindly peruse the decision I have produced before your lordship that is reported in 2019 to ILR cutoff page 81.
Now, please come to this paragraph 20.
My
Paragraph 7.
My
Paragraph 20
My
has been referred. Of validation comma.
My paragraph 20, your lordship.
Yes.
May place it, my.
Yes. Yes.
Madam, here it has been quoted, your lordship will see that the question whether an appeal, that is from page 22. Top paramilot was the seventh line. The question whether an appeal would lie from the revision decision of the single judge in such a case, in our opinion, where the facts and justify a party in filing an application are either under Article 226 or 227 of the Constitution of India, and the party chooses to file his application under both the articles in fairness and justice to such party, and in order to deprive him, not to deprive him of the valuable right of appeal, the court ought to treat the application as being made under Article 226, and if deciding the matter in the final order, the court gives ancillary direction which may pertain to 227 to Article 227, this ought not to be held to deprive a party of the right of appeal under clause 15 of the letter patent, where the substantial part of the order sought to be appealed against is under Article 226. Such view was taken by the Allahabad High Court in so-and-so case, and we are in agreement with it. Now, this case, your lordship will kindly see the decision I have cited, that is 2019 to ILR cutoff. Therein, this case has been specifically also decided, madam. Your lordship will see paragraph 4.
Yes.
2019 to ILR cutoff page 81.
Now, what is there?
And there also this issue was raised, that was under the provisions of Gram Panchayat Act. The decision was taken by the tribunal, challenge in writ petition and thereafter writ appeal. Considering the objection raised with regard to maintainability of the writ appeal and with reference to the...
So, Mr. Sorry for interrupting. This is regarding deposit of some amount.
Yes, ma'am. That is worse, my lord. I'll say this is a final decision. That was the interim matter. And there also it was held that writ appeal is maintainable. That is what I beg to submit, my lord.
Nature of the order.
Your lordship will see. And one more thing I beg to point out, my lord, it has been, my lord, notified by this noble court, whatever application is filed under 227 has to be registered as CMP. It is a civil miscellaneous petition, not as a WPC. It is only when an application is filed under 226 and 227 of the Constitution of India, it is registered as WPC, writ petition.
So when was this writ petition filed, registered?
Writ petition was registered under 226 and 227.
When?
It was filed in 2024 itself. That is, they have not put a date, my lord, here.
All right, 2024. After the rules were amended.
So therefore, my humble submission is obviously the application was under 226 and 227 of the Constitution of India, and therefore writ appeal is maintainable.
Okay.
And your lordship will see, so far as the merit of the case is concerned, it has been reversed on a ground which is not available on record, because the ground on which, my lord, your lordship will see, the trial court has dealt with the fact situation of the case. With your lordship's kind permission, I will only take few minutes to assist your lordship. The issue was whether she is able to read and write Oriya. Which is, in order to discharge the duty as a sarpanch, they are provided with Oriya manuals and they have to read it and write it in order to enable to discharge their functions. Now, in the election petition, the Lordship will find page 16 to the writ appeal, paragraph 3. It was specifically stated that she is unable to read and write Oriya. To this, she replies in the show cause at paragraph 4, saying that I am capable of reading and writing Oriya. Now, one factor which is very important I want to point out to your Lordship is that this respondent was examined by the court, and your Lordship will kindly turn to page 24, the deposition I have annexed. She says, I can read and write Oriya if I am tested in court. Now she gives this statement. Thereafter, the court proceeds to ask her few rudimentary questions which are required for her for discharge of her duty. What the court has asked for is to write Mananiya Goshti Unnayana Adhikar. That means she has to write a letter to the video. So she has to say, Sri Mr. Video, this is what she has to write. And she writes at page 27, Exhibit 2. I'm sorry, that's in Oriya, but if your Lordship will consider, that makes no sense and no meaning at all. Then she was asked to write, Mu Bangadi Gram Panchayat or Sarpanch Ate. That means I am the Sarpanch of Bangadi Gram Panchayat.
A bench, the judges knowing Oriya can better appreciate your submissions. All right. Considering the documents which are in Oriya, it is Oriya let the matter go out of our board to be listed before appropriate bench.
May I just with the Lordship's kind permission, may I just point out, may I pray for a expedite listing because on 10/9/2024, your Lordship was pleased to direct that this matter will come in the top 5 of the.
Yes, that will be listed.
Item 23.
May I please listen? The petitioner in tender has been petitioner has been disqualified from the tender, your Lordship. The grounds which are not available in the conditions, tender condition, your Lordship. May I take your Lordship to directly to that condition for which I have been disqualified? Reason.
Where is that? Where is that?
My Lord, it is at page 15, your Lordship.
Yes.
This is uploaded by the opposite party, your Lordship. My Lord, got it?
Yes.
Page 15. As per specified terms and condition number 5, payment of salaries of wages, service provider is required to pay salary wages under staff deployed at buyer location first and on their own, and then claim payment for buyer along with all statutory documents like PFSI, as well as the bank statement of payment. Done to the staff number 10. The bidder should submit the self-certificate of GSTR. All these documents has been provided at the time of I submit submitted my tender, your Lordship. Then your Lordship may kindly turn to the tender condition, your Lordship, which is at page 20, your Lordship, plus 5. And the next page, it is the tender condition number 5. Payment of salary and wages, service provider required to pay salary and contract staffs deployed at bar on their own and then claim for payment, which I was doing in my previous tender where I was selected, your Lordship, as well as bank statement. I have not violated this terms and condition. But they are saying that in the disqualification, they are saying that tender condition of 5 and the
See, you had not included
my
the amount of EF and ESI component payable to the employees in your.
No, that has been already, because after this, I came to know after when they uploaded the reasons for this, then I replied to them. Which is your Lordship will see. It's page next page, your Lordship.
Yes.
My Lord, I have replied to them that it has been my Lord, 16, your Lordship. Respond to the description. 16. As per tender condition provided, required to pay salary and staff deployed at buyer's location first and on their own and claim payment for the buyer along with the statutory documents like PFS is as well as.
However, as is apparent from the deployed staff and you have not paid. This was the reason before I think. So my submission that in the previous contract, if your lordship will come to last 4 lines. May I say? So I have already, my lord.
Yes.
I have already, these documents, I have already deployed in my standard documents, which also I have annexed in this.
It says in paragraph 5, as per point number 9, you have not fulfilled the criteria of EPFO copy of for minimum 35 persons.
That is been deployed. I have already annexed this. I have downloaded from there. I have already annexed that all the EPF and EPF certificate has already been uploaded in there when I applied for the my GSTR 2(3)B and PF certificate also. That has already been uploaded. I have annexed to this my petition, your lordship.
Already means what?
When I applied,
you have not paid their wages for the month of February.
My lord, what has happened at that point of time, due to the intervening holidays of holy holidays, there are some little bit delay, but thereafter it has been paid, your lordship. So first they said okay, 9 tender condition for violation of tender 5 and 10.
Though the previous contract has been has a contract, you have failed to submit the statutory document, namely PF and ESI bank statement reflecting payment made to the contracted staff.
I have already given. The documents are there, my lord. First, what has happened, your lordship? First they contract 5 and 9. Then I respond to them, page 16, I respond that this is from the page number so and so, so and so, so and so that. Thereafter, when I reply to them that it has been complied with, then they again come with another response to that concern that you have not deposited. If your lordship will see that EPFO for minimum 35 number of persons. That was also uploaded in my tender documents,
So
which I have already.
This objection was given subsequently after you replied to the first objection.
Yes.
Where is that?
That is my lord, may kindly see page 15 is my first objection that the reason has been uploaded.
Their objection is at which page?
Page 15.
Page 15.
The reason they uploaded in
Wait. Page 15. All right.
That was the tender codes number 5 and 10. They say GSTR 35(3)B has not been uploaded. Then I respond to them on page 16. I respond.
Wait. Along with statutory documents like PF, etc., bidder should submit all this. So this you had given?
Yes. So I reply them. On next page, I replied to them. Dear sir, as per your requirement, point number 5.
So the first one, 5 is that first you should pay them and thereafter claim payment
Yes,
from the buyer.
that I used to because
Wait.
My.
That you used to, but you yourself are saying that for that particular month you have not paid.
They say that the probable is equal to pay salary as so and so by along with other as a bank statement as we have worked the certificate. We meet all your requirements in point number 10.
So there are 2 objections, 5 and 10.
First they said 5 and 10. Then when I respond to them, that these are the page number 4.
5 is not one. 5 is so many. 5 says payment of salaries and wages. You might have told them that yes, we have been paying.
Yes.
Then they are pointing out that for this month you had not paid. So therefore you can't say that those were not there in the first objection.
No, that is I have paid my lord.
No. You are saying that they came up with new objections. I don't think so. They are saying that same objection you have not answered.
No, that has been answered.
You answered, but they have not accepted. That is where that same thing they are pointing out.
And again, another point, my lord, EPFO. Second
EPFO was there.
Earlier it was, my lord, may kindly see.
PF, ESI, etc.
That was there. I said, okay, this has been uploaded.
So it is all inclusive, this condition number 5.
As well as the bank statement paid to the staff.
My lord, that was if your lordship will.
So according to you, everything was compliant with.
Everything was compliant.
What is the affidavit, counter affidavit?
They have not filed any counter affidavit so far.
Was there any direction?
My lord, notice was issued and the
Yes.
government has already, the central government, that
Mr. Panda,
it is
oh,
the,
union government.
yes, you know.
Yes, who is for the,
Let us see, notice has been issued, a copy had been served.
Yes,
Had filed this petition.
and this tender is only for
who
1
is
year.
opposite party number 3?
Mr. Padhi has-
Three is the, because now after cancellation, they awarded this tender to the opposite partner number 3.
Just,
So opposite party number 3 is appearing.
notice has been issued.
But their last 2 days, they are not appearing.
So whether they have entered, the notices were served.
Yeah, Lord,
Yes,
yes,
yes.
request has been filed.
Counsel have appeared. Mr. D.P. Sahu is appearing for OP3. And 1 and 2 is DSJ, he's not appearing. Notice has been served. Receipt has been served. Receipt has been served.
Oh, fresh steps were taken.
Second time, as per your lordship direction, I took second time, I also
Nothing says.
request has filed.
Which? 27.
That office notes dated 2/7/2025.
Yes, who is appearing for this Union of India?
Name also appears. Indian Employment.
There is no representation on behalf of the opposite party number. On behalf of opposite parties. Does this matter on Monday? Monday.
Mine.
Item 24.
Just Mr. CGST and CX.
Mine.
Will Mr. Padhi appear
Yes,
or
yes,
Mr.
we-
Satpathy will appear?
Now, Mr. Padhi will appear because Union of India is there, notice was issued, they accept notice. If lordship will see the orders also previous.
That is the material. Who had floated the tender? Who had floated the tender?
The CGST, your lordship.
Huh?
CGST, your lordship. Is the opposite party number
How
2
did you-
year. 2.
Yes. Yes.
My lord, in this case, the present petitioner prefer operation is a stone quarry. That is Khanjamal, by the quarry number 59, plot number 263, khata number 144, madam. And what happened, madam? The present petitioner got the lease agreement on dated 28/8/2019, running page 18, madam. That lease agreement is valid for the 5 years and last to 27/8/2024, madam. Your lordship kindly peruse the opposite party issue the environment clearance for the operation of the stone quarry, my lord. That is annexure, my lord. Annexure 4 series, my lord. Running page 57, my lord. Lordship got it, my lord.
Yes.
The pursuance approved mining plan as regards Consumer Stone Quarry number 59, submit the mining officer Baripada Circle, Baripada, as per the agreement of lease deed so and so affidavit agree grant to EC communication of the members secretary DIA by letter number.
Yes, have you what instruction?
We have filed a preliminary counter affidavit where we have taken the stand that because of the intervention of the Green Tribunal, Honorable Green Tribunal, the matter was stayed. Then ultimately, when the Honorable Green Tribunal lifted the stay order, observed at Malot page that the all statutory clearance should be made available to them. Now, the Green Tribunal's order has been violated, and against that violation, he is before your lordship.
My lord, this agreement is
That page, Millard,
Who has violated the Green Tribunal's order?
additional affidavit, page 11.
So who has violated?
The statutory authorities are, his case is statutory clearances are not being issued in his paper by the statutory authority. He has made the statutory authority OP number 5. He says that OP number 5 is sitting tight over the matter.
Who is OP number 5?
I'm sorry, I'm OP number 6. Chairman, State Environment Impact Assessment Authority. And Honorable Green Tribunal says that the statutory authority dealing with the clearances are directed to dispose of any pending application before them submitted by any one of the applicants expeditiously. Now he is sitting tight over the matter, and without that clearance, we are unable to allow him to operate.
Who is sitting tight?
That OP number 6.
OP number 6 is your body.
No, we don't have.
Environment assessment.
We are not appearing before.
No, but he has annexed memo along with the document stating that mining officer stating that after he obtains the EC. Acha. So EC will be granted by who is that?
EC granted till 31/3/2021. That agreement, lease agreement done after environment clearance of the Green Tribunal manner. Because previously I have already submitted some judgment which is passed in other cases manner after Green Tribunal order manner.
So who appears for German State Environment Assessment Committee?
In last occasion, your lordship directed to take instruction for the opposite part number 6 manner. After your lordship's interference, they have admitted in a counter manner, I have already considered your case, but after cluster issue will come. Your lordship kindly peruse their counter.
That is the mining officer, not
Yes,
the
madam.
environment.
Say admitted, madam.
What
Admitted that after clearance of the EC, then I will consider your case. But in the meantime, my lord, in this period already pass out, my lord. Because only we have operated only 2 years, my lord.
So,
but 5 years our agreement. Due to non-issue of the environment clearance by the mining officer.
So what can be done?
My lord, quarry operation not done, my lord.
So
What can be done?
What were you doing? Why did you not obtain mining clearance?
Oh, every time I have already.
Do you want us to extend that period?
Yes, my lord.
Can we do that?
Yes, my lord.
Yes.
My lord, due to the technical difficulties.
Technical difficulty, you will have to apply.
We are not difficult.
Not in this jurisdiction, not here.
My lord, that is the difficulties of the opposite party.
Mister, you have not approached them for
Yes,
extension.
approach, my lord. Your lordship kindly peruse.
Then where?
Yes, ma'am.
Sought the present period for extension of period.
My lord, I'm
Case 13 of the writ petition.
What, my lord?
Suppose you extend the period of your lease.
Yes, ma'am.
2 years, 6 months.
Yes, ma'am.
And you don't have an EC, what will happen?
We are not operating. So that is the technical difficulty.
Technically, with your prayers, you will sit with the order.
Mr. Counsel, in fact, I have no problem. Yes.
The mining officer, similar matters regarding that what? Khanja.
Khonjamala,
Wait. Khonjamala stone quarry, because all those by a blanket order have been stayed by the NGT. So in some cases, maybe last year, not this year,
last year.
some extension has been granted. But those maybe where everything, all permissions
Yes,
are in
that we
order.
have adhered to at annexure A/5, that we say, we are not standing on we say that the mining officer says that will consider a merit after obtaining the cluster issue over the fungible stone body. He is to solely pursue before the OP number 6 authority. My lord. He has to obtain that issue, we have to consider his case.
Issue will be granted by the Tahsildar environmental clearance officer.
They are not the environment, they are not OP6.
In last occasion, your
Proceeding
lordship,
against all the opposite parties. All the opposite parties is seeking relief.
my lord, your lordship kindly tell the annexure 11, 75, page 75. This is information joint reassessment has been conducted in the dated 3/3/2020 regarding the actual extract. The actual extraction of the minor mineral from your fungible stone quarry 59, it is reported you extracted.
And where are those orders where the period has been extended?
So many cases. I will submit, my lord. Next Monday I will submit.
All right, as requested on behalf
Other
of
cases, my lord.
Monday you can. Monday is day after tomorrow.
Tuesday.
Tuesday, my lord. Other cases I will. And Tahsildar also mentioned, my lord.
Please examine that decision of this case, of this court, that JDA.
Limestone.
Yes, present petition also filed royalty, my lord.
Yes.
You are further informed that after verification, gas record ascertain that during the lease period, you have deposited royalty 5707 from about the extract of the money, extracted of the one for
This is a different cause of action.
No. Same cause of action. My lord, I have deposited all royalty.
More than one cause of action.
Let me submit.
Do you know what is chorus?
My lord, I have submitted all royalty, all the things and mining approval.
We will see.
But due to the issue, not issuing the issue, we are not
we will see on Tuesday. In fact,
obligement.
One judgment has been rendered by me on the point of extension.
OA is what number? What is the number of the OA before the NGT?
I have also a copy, my lord. I have already previously.
Number. What is the number? Please tell me.
OA number 116 by 2015 EG. I will submit it previously.
Okay.
In additional affidavit.
116 by 2015. And OA number was 70 by 2017.
JDL presentation.
Yes, we will take up case on Tuesday.
Tuesday.
Item 25.
In therefore, Mr. Samantra, I pay next to my lord, he has some personal difficulty.
Who?
And therefore, Mr. K.C. Samantra, I pay next week, my lord, he has some personal difficulty.
As requested on behalf of the petitioner, this matter on week. Yes.
I found it.
Next.
Item number 26.
May I please?
26, Your Lordship, we have received information.
Yes.
Lordship, can peruse your lordship
Yes.
last.
Yes.
We have received instructions, Your Lordship. Lordship may permit me 1 week time, then I can file a detailed counter affidavit or subject on the basis of the instruction.
This is regarding removal of encroachment from a government land which has been reserved from modular committee for construction of the SSG building.
You can go to the subdivisional officer.
Your lordship's order.
That you can follow.
Your lordship's order in the case of Trinath Ponda is very clear, man.
Yes.
Despite that, the Tahsildar is not taking any action, though issued notice for eviction, but not removing the encroachment. And the petitioner is the Sarpanch. She is
There is
trying.
no direction for removal of encroachment. There is direction for consideration.
Your lordship's judgment is there, man.
Yara inquiry says that she has constructed a house there for the
Yes.
past 25 years. She's dwelling on that land. And that land is position notice Mahila Samiti, Your Lordship. That the RI has inquired into, Your Lordship.
No, but without evicting her, why have you allotted that land to the Mahila Samiti? If you are saying 25 years, she will go under that OPLE Act, Section 8A.
Your Lordship, they are now trying to, because their income is less than 90,000 per annum, they are looking for a suitable plot to allot her under the Vasundhara scheme of the OPLE.
File your affidavit.
And they will.
File your affidavit. 2 weeks.
2 weeks.
2 weeks for time is allowed for the state to file counter affidavit.
Item 27.
27, my lord, 2 weeks time may be granted to file counter affidavit.
Yes.
Yes.
2 weeks time may be granted to file counter.
Yes. 2 weeks.
Item not
As requested on behalf of so and so. Is this matter on so as to enable him to file a counter affidavit.
Item not 28.
Yes.
Lordship, the dealer gives you. Counter and the Union of India.
We stand to file counter, my lord, in this case.
Weeks further time is allowed for the opposite parties to file counter affidavit. So many adjournments have been granted.
We have received the guideline, which speaks that every year it will be inspected for the course the period provides. After that, after patching of the fast bag, then they will be provided with the recognition and for the period the course is meant for. So in case of
File your affidavit.
yes.
Item 29.
May it please, my lords.
Lord, I appear for the petitioner, my lord. Lordship would be pleased to see, my lord, order number 3 dated 10/9/2024, my lord.
Yes.
My lord, may I place the order, my lord?
Yes, why counter affidavit has been filed?
No. 2 dates taken, my lord.
Despite opportunity granted to the state opposing case, no counter affidavit has been filed. By way of last indulgence, 2 weeks further time is allowed for the state to file counter affidavit, telling which file counter subject to payment of cost of rupees 5,000 to be deposited in the account of welfare fund. Yes.
Deeply. 30. Grateful.
May I please receive? Lordship, in this matter, my sole prayer was to provide the completion certificate. But they have filed the counter saying that the work is not completed. So I need to file the reply to that. It's only 1 week time.
Work was not completed, then what can be done? We
There,
cannot go into such disputes.
Lordship, they have admitted that work is completed in all respect. That page 56 of my writ petition.
Then you can file a suit.
I will file to resign it to that.
Counsel appearing on behalf of the petitioner seeks adjournment to file a rejoinder to the counter affidavit. This matter of 4 weeks. Yes.
Item 31.
First, honorable and counsel for the petitioner to file counter rejoinder to the counter. Yes.
May I please, your lordship? I may be permitted from virtual mode. I am appearing on virtual mode.
31.
For opposite parties were 1, 2, and 3. Therefore, the 3 to be there. For opposite parties there.
I am appearing for the petitioner, your lordship, in this matter. I may be permitted to appear virtual on virtual mode. Here, the petitioner has challenged the floating of a fresh tender amongst other grounds of irrationality, illegality committed on behalf of the opposite parties. Now, my lord, as per Annexure A3 series, an award was, the petitioner was given an award for running of taxi tour and taxi travels at Jharsuguda Airport.
My lord.
So have you filed your affidavit?
My lord, I have filed my lord, affidavit, my lord. May I draw my lord's kind attention to the prayer of the petition?
No, whether you have filed or not.
Yes, sir. Now,
let us see your prayer.
The award is, your lordship.
Let us see your prayer.
Yes, sir.
So you want us to pause the tender process?
No, your lordship. They have now terminated. I had a similar contract, and which was for the period for 3 years. It was to commence from 22 till 25. But prematurely, they have terminated my contract. The grounds what I have taken, your lordship, in this.
Whether any arbitration clause is there?
My lord, there is.
No, your lordship. There is an
Page
dispute.
121.
There is one dispute.
Page 121.
Dispute resolution.
Have you invoked dispute resolution?
Page 121.
No, your lordship, exactly. That is what the dispute resolution is at clause 22.1, page 216.
Yes.
That is one of the grounds they have taken now.
Yeah. So you could have invoked.
No, your lordship. Dispute as per the tender contract is the conditions which have been flouted are not covered under the dispute. Here, my particular case is the tender conditions have been arbitrarily violated. That doesn't come under the dispute provision. Clause 22.1.
Yes.
May I read out, your lordship?
Page
216. May I read out, Your Lordship?
Just a minute. Yes.
All disputes and differences arising out of or in any way touching or concerning this agreement, now, except those the decisions whereof is otherwise herein before expressly provided for or to which the AI Act 1994 and the rules framed thereunder which are now enforced or which may hereafter come into force are applicable.
So there is no dispute.
No dispute, Your Lordship.
Then why have you filed the petition?
My Lord, I am just coming to my grounds. This was a composite contract, Your Lordship.
Mr. Counsel, if there is no dispute, if everything is admitted, then why have you filed the writ petition?
Because they have flouted arbitrarily.
They have flouted arbitrarily and they are saying they have not done it arbitrarily.
No, they have done it. They are admitting. They are admitting.
Up to you. Don't.
I will just place one document before Your Lordship.
Sorry. We have seen the dispute resolution. You don't want to invoke, don't invoke.
But my Lord, that is says except
Sorry, we cannot go into such disputes. If there is no dispute, then it's all right. Don't invoke. Next.
But arbitrarily they have done something which
arbitrarily, that is the dispute. You are saying there is no dispute.
But being an instrument
because the action is arbitrary, therefore there is no dispute.
Dispute in the sense, suppose they are committed to give me a space. They remove me from the space.
Then we are not here to convince you, Mr. Right. Next.
Item 32.
Yes, Mr.
As per last order, Your Lordship had directed to open inspection as to whether the portal will be
Dispute
open after
resolution,
20 days.
page 216. Yes.
As per last order, Your Lordship had directed whether the portal will be open. The instructions are that the portal cannot be open, and the period specified is 180 days. And there is a specific method by which the portal can be opened as per clause 24.3.
No, what was our order?
Last order, Your Lordship. 14 November 2024.
November.
The tender condition provides 90 days. Guideline provides 180 days, Your Lordship.
14 November to bring on, sorry, this is wrong.
Yes, what is your instruction? File your affidavit then.
Let's 3 weeks time may be granted for
No, Lord, then it will, I have on more than the 105 days. Your Lordship, may already 2 chance given. A short date may be given. That's my humble request. Lord, I am suffered. Condition provides 90 days. I am in suffered on portal block 105 days as on today.
For applying for unblocking the portal. As per the conditions of the contract, read with the OPWD code, there is a method by which process by which they can apply for unblocking of the portal by depositing 10,000 rupees. That option is open with the petitioner.
So why have you complied with?
I am challenging the portal process, Your Lordships. The blocking of portal registration, Your Lordship, in the month of October, please to issue notice. And in the meantime, tender condition period. No, I am ready to apply because yes, what I am only submitting, because they have today instruction, they will not to unblock the portal. Suppose I apply, they will not unblock me.
No, they don't say that. They say that can be unblocked only if you make the application.
So that's the
application. You can make
that observation maybe
without your
I'll highly oblige, my lord. If I file application with statutory deposit, they may unblock me. That observation disposal.
My lord, there is no instruction as to that they will unblock.
No.
That is a proper procedure.
That is the procedure.
180 days is mentioned in the OPWD code. 90 days is mentioned in the contract, but OPWD will is what is referred to.
OPWD will not override the contract.
My lord, it will, my lord, it must refer to the clause.
Annexure 2, the conditions, page 92.
page 84 where 92 my learned friend is referring to, it refers to Appendix 9A of OPWD Volume 2.
70?
84, my lord.
84, yes.
It guidelines under second line Appendix 9A of OPWD.
Which clause? 84, which clause?
84, my lords, at the top guidelines, thereafter Appendix 9A of OPWD Code Volume 2.
Appendix 9A is there, but
Yes, my lord, then,
Guidelines.
Guidelines.
Okay.
And as per the guideline, it is 180 days.
where is that?
Which clause? You're saying page 84, which clause?
Not, my lord, not the leadership, second line from the top, Appendix 9A is mentioned.
That we are seeing. But you are saying that the a portal can be blocked for 180 days.
My lord, as per the OPWD code, which was amended in 2017, now the prescribed period is not less than 180 days.
All right. Yes, you are relying on which clause, Mr.
Page 92, my lord. Same annexure, my lord, annexure 2.
92, yes.
Clause 24.3, my lord.
Clause 24.3.
Your lord, sir. The minimum period of blocking portal resistance shall, in case, be
minimum.
Yes, lord, sir. So there is no maximum also fixed, my lord, in this. My lord.
This is what she is saying, and even in our order we have mentioned that minimum period is 90 days.
This, my lord,
They had an option, but they are saying that we don't want to portal. So because of this minimum thing, we can't force them.
my lord, minimum already over 105, your lord, sir.
Minimum is open, maximum.
If they are deciding to impose minimum, then it is over.
So the condition is minimum, my lord. That's subject to your lord, sir. They will find short.
This is what we have recorded in our order also.
Yes, lord, sir.
As requested on behalf of the opposite parties, is this matter on 3 weeks. So enable her to seek instructions. Enable and AACs to seek instructions and file affidavit.
Maximum is 180.
No, not less than
No,
now.
no.
Now the
180.
period has gone up to 180, not less than 180.
Oh.
Not less than 180.
Item 33.
Oblige.
This case ever say received the counter on 18/11/2024. I would like to file a rejoinder.
And for the petitioner seeks adjournment.
3 weeks time can be given because I collected some documents.
Twice is
I
under
bought
to the
documents.
counter affidavit. File on behalf of the opposite parties. Yes.
Item 34.
I'm asking for opinion 9. He's trying to find countermand.
They are going to, they are already constructing rapidly. Is the Kalyan Mandap, is the commercial, on the playground, only the playground of the students of the Palace of the last school. That's why I heard in spite of the lordships rapidly, only to your lordship only. See how they are going to construct.
So that is what has been mentioned in our order, that will be subject to final.
But without sanction, yes.
Indicated in the cause list.
Have you filed your appearance memo or Bharatnama? Then it will be indicated.
And without work order, there is no work order. So far as my knowledge is concerned, your lordship may ask them to file the work order also. Without in work order, they are constructing. This is illegal.
Since I have appeared on behalf of the opposite party number 12, my lordships, who happens to be the headmaster of Balasur Jila School, Balasur, my lord.
Yes.
My lordship, I have appeared before your
What
lordship.
did you say? Is it being illegally constructed or with your permission?
Completely illegal, my lord. My lord, I want to submit a single sentence that the Rural Works Department is constructing a MPH, my lord, which is known as a multi-purpose hall without any work order, my lord.
Okay.
My lord, it is my humble submission. Baleswar Jila School was established in the year 1853, my lord. Age of which is 172 years, my lordship. And that is the only playground of the school.
All right. How many students are there in your school?
More than 800 right now, my lord. That is the only playground, my lord.
July schools in the estate are in very poor condition. Therefore, we wanted to know.
My lord, at present,
Discuss 2 weeks further time is allowed for. What's the party number?
9.
9 to file counter affidavit. Stop. Mr. Nayak and counsel has appeared on behalf of principal of July School.
Headmaster of July School.
my lord. Headmaster of July School, my lord.
July School. Stop. He has submitted that the work in question is continuing without any work order issued by a competent authority. Stop. In the counter affidavit, it will be obligatory for the opposite party number 9 to bring on record to counter affidavit any work order issued by a competent authority for construction of the structure over said to be over land which is a playground of July School. Of the July School. And then the moment you say,
Oh, the spot date will be given because they have
weeks.
2 weeks.
2 weeks. Date will be date.
Date.
2 week date you will get.
Oh, like
16th.
16th.
My lord.